I am now going to turn it over to one of our wonderful attorneys over at our main branch, the Pompano Beach location. Let us now hear it for Emily Gannon. Emily, and you know what? I'm not going to call you accidentally today. Take it away.
Thanks, Jeff. So I forgot we actually that's why we're doing this sort of so soon after I just did it because I forgot we sold out last
We
time.
sold out last. Oh, and,
Uh
and and somebody did place in the chat something that I failed to mention. Emily, pardon my interruption.
yes, go for it.
The two types of CE credits today. Thank you, Stephanie. I'm going to add that to my notes for next time. CAM credit, one CEU in
Yes.
the OPP category or an elective, assuming you have not taken this class in the same renewal cycle. The DBPR only counts each course number once per cycle. If you're a manager and you've taken this between now and a year and a half ago, this current cycle, this class will not count twice, not even for an elective. Just keep that in mind, okay? And also, while we will mention a couple of things about condominiums today, there will be some references to condos. This class does offer CEUs. It has everything approved by the DBPR for HOA board member CEU. Okay, Emily. Again, thank you, Stephanie. Back to you.
Yes. So today's class is it is sort of a general course. So you will have the slides as Jeff said. Um, but ultimately it sort of ends up being a little bit of a conversation. Let me share my screen and then we'll make sure I do this right, and then we'll get into
You always do it right.
all right. All right, so there we go. So here's
Yeah.
our little intro. So really we're talking about updating your governing documents. So we are going to talk about condos and HOAs, but lucky for HOA guys, you get your credit today. So there you go. All right. So a little bit about me and a little bit about our firm, just real quick. I'm going on 14 years this year here at KBR. The firm itself has been around for a long time. All we do is association work. So it's just that's I, breathe HOA condo world every day, all day. We can help you with pretty much anything you need. If you're reviewing contracts, if you're doing big projects, if you're amending your documents, hint, hint, that's probably why you're here, or thinking about it, we can help you with that. If you have questions about your election, just general operations, who maintains, the windows, who does this, we can review your documents, help you with that. But that's sort of a brief intro on us. Like Jeff said, I'm down in the Pompano office, but we are kind of, I joke that we're slowly taking over Florida. We are mostly in South Florida, but we also have an office up in Tampa and an office up in Orlando. And obviously now with Zoom and emails and all of that, we can pretty much cover you wherever you are and in the state of Florida, and shouldn't be a problem. All right, so let's jump in. So today, like I said, it's a bit of a general course. We are going to touch on a number of different topics just by nature of talking about amending your documents. Because of that, we jump around a little bit. We cover a lot of different things. As Jeff said, hold all your questions to the end if you don't mind. It is a little bit of a looser format. We're going to kind of just chat about some things and hit some key points and some things you might want to think about if you're thinking about doing your documents over. So, all right, there's my little profile. All right, hierarchy of governing documents. Let's start there. You're going to hear me say governing documents 1,000 times today, so I'm sorry in advance. But here we are. I'm going to say a couple things probably over and over again, but they're the important points, so that's what you're going to have to pay attention to. Governing documents, that's the big phrase, right? That's the overarching topic that we're talking about today. And that encompasses all of the documents that essentially cover your condo or HOA. That means, and again, these are different actual documents. Your declaration of condominium, if you're in the condominium world, your articles of incorporation, your bylaws, and then any rules or regulations, ARC guidelines, maintenance standards, any other policies you might have. That's the hierarchy too. So we say them in that order for a reason. For condos, it's your declaration of covenants and restrictions. It may not have that exact name. It might be a declaration of easements, a declaration of covenants and conditions and restrictions, some variation of that. Then your articles, then your bylaws, then your rules, and your architectural guidelines. And we joke that, back in the day, there was that ad that the advertisement that said a little dab will do ya. That's how you can remember the hierarchy. So it's declaration, articles, bylaws. Now, they are different documents, and this is important because we hear people kind of just use terms of art, and you'll hear someone say, our bylaws say this, or we want to change our bylaws. Well, you might want to change your bylaws, but you're probably actually talking about your declaration because, again, those are different documents. So try to use the right terminology when you are talking to, your community or your manager or to your attorneys. Have an idea of kind of which document you are talking about. Your declaration is the one, again, typically you're probably addressing and you're probably talking about. Your declaration contains all of the covenants, all of the restrictions. That should really be what has your use restrictions. So anything that involves ARC guidelines or ARC requirements, anything involving pet restrictions or leasing restrictions or sale approval rights, or any requirements about how you maintain the lot or your unit and things like that. All of that stuff, which is for the most part kind of your day-to-day topics, those are going to be covered in your declaration of either condominium or your declaration of covenants and restrictions. That's why we kind of say that's the most important one. Now, it's not the only document here. Your articles of incorporation, that's the document that you file with the state. That's what set you up as a not-for-profit corporation. That's filed with Sunbiz when you go to that website. And then you have your bylaws. So your bylaws also contain kind of your governing terms. So how many board members you might have, or your notice requirements for meetings, things like that are usually put in your bylaws. Sometimes in older communities, they did put some restrictions in the bylaws. We would tell you that really any restriction should be in your declaration. So that might be something you want to look at and consider. But sometimes some rules are attached in your bylaws or things like that. But typically, if we're talking general everyday, use restrictions, that should be in your declaration. Then we have your articles of incorporation, then your bylaws, then your rules. And that's the order if there's any conflict ever. All right. And if we're talking about co-ops, if there are any co-op people here, I know it's a little different. You don't have a declaration, then it's your bylaws and your proprietary lease and that sort of thing. But you guys are kind of in your own world a little bit. All right. So the amendment process, that's really what we're here to talk about. Do you want to change your documents? What does that entail? How do we do that? What does that mean? So how do we amend your governing documents? Generally, keep in mind, Florida case law basically has a 5-year statute of limitation on any challenges to any recorded amendments. Now that's important because recorded is when it becomes effective. To amend your governing documents, your declaration, your articles, or your bylaws, any of those, first of all, you have to look at them, and they may have different thresholds. Your declaration might have a threshold of, a 75% approval of the membership in order to amend, whereas maybe you're one of those lucky communities and your bylaws can actually be changed maybe with just a board vote. That's rare, but it happens sometimes. So that would be, again, where we have to compare those thresholds and make sure we're following the right one. Each document probably has its own amendment provision. So again, look at that very carefully. But to amend properly, we present the proposed amendment to the membership. We get the right number of votes. We have to file a certificate of recording, and we record the amendment in the public records of wherever you are, in Broward County, Miami-Dade, Palm Beach, Hillsborough County, wherever else. Once it's recorded in the public records, now everybody, under the sun is on notice of that amendment. Now it's effective. So that's the effective date, is once it's recorded in the public records, which luckily that's gotten a lot easier in the last couple of years because we can record most stuff online. So you can get everything recorded probably in a couple of days, whereas before we'd have to mail it and hope it, got recorded in a couple of weeks. So you have a 5-year statute of limitations to challenge any amendment. So sometimes that happens. You have an owner that comes sort of out of the blue and says, hey, I don't think this amendment was properly adopted. I don't think we got enough votes, or whatever the issue may be. If that amendment has been in place for 5 years and recorded and effective for 5 years, then that owner's barred. Their action is already, is done before it even started. And now how do we get these votes? How does this all work? So you can do it at a meeting. That's typically the easiest way to do it. There might be a method to do it through a written consent process. You have to look at your governing documents. If you're an HOA, typically you're allowed to mail out the amendment and let your owners just sort of mail back a consent. If you're in a condominium, you'd have to have affirmative language in the documents that let you do it that way. So it's a little different. You might do it through proxy voting. You set up a meeting, you send a proxy out to everyone. Hey, do you approve of this amendment? Are you for or against? And they can vote on that proxy and mail it on back, or deliver it to the meeting, or send it to management, or have someone else hand it in. The proxies are good for 90 days. So if you set a meeting for, whatever it is, April 1st, you have a 90-day window from the date of that meeting. So the original date of the meeting. So from April 1st, those proxies are good for 90 days. If you can't get your vote, and you don't have enough votes on the date of your meeting, you could always reconvene. You could come back. Those proxies are still good because, again, they don't expire for 90 days. So you could have another meeting maybe 30 days later. In that time, try and get some more action, get some more, involvement, get your owners to vote, get some more proxies, try and gather, knock on doors, that kind of thing. And then maybe sort of at the second go around, you get enough that you get the amendment to pass. So again, proxies are really helpful because you don't actually have to have your owners come out to the meeting. They can vote, and hand in a proxy, and they don't have to come. For certain amendments, you have to keep in mind that there are going to be kind of sometimes different requirements. Now, the first thing we're going to tell you in general is look at your governing documents and see what your voting threshold is. A lot of your governing documents might have that outdated older language where you do have a very high threshold, where maybe the threshold is 75% or 2/3. And the biggest complaint I get, or the biggest question I get from this class, is always, hey, we can't get our owners to show up for anything. We can't get the involvement. What do you recommend? What do we do? How do we get people to pay attention? How do we get people involved? Well, it's frustrating for me to even answer because I don't have a magic wand and I can't help you too much with that. Ultimately, my tip is going to be look at your voting threshold. If it requires a 75% vote, 75% of your owners to approve an amendment, that's a very high threshold. So if you could start with amending just that provision, bring that down to a number that you think you can, everyone would be comfortable with, but that you could reach, maybe just a majority of all of your owners, or a majority of owners that are eligible to vote, then that changes the game. Now, if you have a community of 100 owners, and you go from having to get 75 owners to say yes to something to all of a sudden, now we only need 51 owners to say yes to something, that makes life a little bit easier. So that's step number one. And that's the biggest tip you can have as a takeaway from this. Really look at your amendment threshold, see what your number is, see what the percentage is, however it might, be worded, and get that down to a more attainable goal. That's number one, because everything else we're going to talk about some ideas of what you could actually change in your governing documents. But realistically, if I don't want to spend the time and the money for you guys to draft everything, put together these lovely new governing documents for you, if they're never going to get adopted. So that's step number one. And I would always say sort of, you think about doing this maybe in phases. And that would be phase number one. Get that amendment in place. It is going to require that higher threshold originally. So to get us down to a majority, you're still going to need whatever that original number is, the 75%, 2/3, whatever it is. But that's going to be a little bit easier. And maybe you can sort of sell that to your owners as, hey guys, we have all these great ideas, but our hands are tied. We're never going to get the numbers. Please, 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 vote in favor of this amendment so we can get it, so we can move forward. When we talk about leasing and sales or leasing and rental restrictions and those amendments, there's a little bit of a difference in terms of how those are handled. If you're going to do an amendment that involves lease restrictions, the statutes and 718 and 720 both have sort of almost a statutory grandfathering worked in, where depending on the language in your documents, the age of your documents, if the statute is going to control, essentially the amendment may not apply to everyone. The amendment, if we're doing a leasing restriction, may only apply to those who vote in favor or those who vote or those who take title after the amendment has become effective. So that's something to keep in mind, and that's something to talk to your attorneys about if leasing and lease restrictions are something you're considering. Suspension of voting rights, that's an important topic because, again, depending on whether you do suspend voting rights, you don't suspend voting rights, if that authority is in your governing documents or not, and again, the age of your governing documents. If you want to suspend voting rights, in theory, it sounds like a nice little penalty if you have owners who are, not doing what they're supposed to be doing. That's one enforcement tool you do have, is to suspend voting rights potentially. But when you do that, then that changes the analysis. Now we change the numbers. That takes that owner out of the mix in terms of quorum, all of those things. So that may change your, the math. Now, whether that makes it better or worse to get or easier or harder to get the amendment passed, depends. So that's something to consider. Talk to your counsel about. Typically, in our experience, we found if these are problem unit owners or problem owners and you suspend their voting rights, it doesn't change much, because if they were problem people, they probably weren't voting anyway. And maybe it's easier to have them counted in for quorum purposes and not suspend their voting rights. But again, those are all things to sort of consider and think about. Mortgagee approval, that's another key thing when we're talking about doing amendments. Your governing documents, a lot of them, will provide that if you adopt an amendment that impacts the lender in any way, shape, or form, it requires their consent. Now, in a vacuum, that sounds like a big hurdle. Whoa, wait a minute. I'm supposed to get consent from all of the lenders in the community? How in the world would we do that? Well, the statute actually does give us a procedure. It outlines essentially how you can get that consent, and it's through a written mail out process. And it's really a negative notice process. We do a title search on the units or on the lots. We get the actual lender information. And then it's a mail out. You send them a notice that says, hey, we're adopting this amendment. Unless you object by this date, you're presumed to have consented and we can move forward. And you get everybody, to agree that way. So it sounds a little scary. It sounds like it would be a big hurdle. It's more of an administrative extra step, but typically it's okay. But that's something else to keep in mind. If you are doing certain amendments and your documents require mortgagee approval, that's another step. That's another thing to factor in. If you are going to have to run title searches for every unit, if you are going to have the attorney spend extra time to look into that, that's another thing to sort of factor into this whole process. All right. So why we do this class in general is, other than the sort of basics of, well, we think we need to update our docs because they're 50 years old and we've only had a couple amendments and they have old, outdated language, still talks about the developer. Well, more importantly, you probably have a lot of provisions that are, and we put in here illegal, but really problematic because they might be discriminatory. They might expose you to possible liability, essentially, without even realizing that you have that language in there, or without even realizing that that threat is sort of hanging over your head. You might have outdated language and provisions that are holding you back in terms of money. I'm not a gambler, but the expression that you're, leaving money on the table, that's what a lot of associations are doing. If you have, old language and you're not recovering as much as you could recover from a foreclosure, or you're not getting as much as you could from your delinquent owners, why not update that language and let the association recover as much as it can? So these are some of the considerations. And then that's in addition to what everyone typically thinks of in terms of, well, why would we want to amend our documents? Well, because they're super old. And the more important thing, not just because the developer's mentioned 8,000 times and our developer hasn't been around in 45 years. It's not just that the developer, is mentioned 1,000 times. It's that when these documents were put together, they were drafted by developer counsel. They weren't drafted by, counsel that works with you guys as your actual community now, and how your community operates now. That wasn't really the consideration at the time. They drafted the documents with the thinking of, well, we're working for the developer. We want to make this community appealing for lenders. We want loans to be coming in. We want lenders to be able to come in. We want to be able to sell these properties or these units. That's what all the developer was really thinking about. And they obviously cover certain bases and certain restrictions and all of that. But that's really, for the most part, going to be their mentality. For you guys now as owners in these communities, it's a whole different ballgame. You're probably not living there thinking just about, what's attractive to a lender in our community. That's probably not the first thing you think of when you think about what benefits your community. You're probably thinking about how everyone lives there, what can improve the lifestyle, what restrictions really make sense for your community, what don't. If you're a 55 and over, times may have changed. You may need to revise some of your language, things like that. If we need to think about, again, lease restrictions that maybe weren't a problem before, you know, parking, all of these things that have kind of changed through the years. There's a lot of language that's still in old documents about, domestic servants and things like that. We don't really use those terms anymore. So other things that need to be updated just for those reasons, but really just to make your documents suit how you live in your community now, but also how the association can be saving money, recovering the most money possible, and then getting rid of that risk of any of these lawsuits, discrimination claims, things like that. We want to make sure you guys are safe and protected. All right. So we'll jump into some of this stuff. All right, some of the examples. And like I said, we cover kind of a number of hypotheticals and little scenarios. So we kind of jump around some different topics, but let's jump into them. And again, these are more talking points, and I'm going to give you some examples and things like that. And then we can address any questions at the end. So first one, and when we do this in person and interactive, we can do it as a true false, and I can ask you guys to raise hands, but I can't see you. So I'm going to tell you the answer anyway. A foreclosing lender is required to pay 1% or 12 months of delinquent assessments, true or false?
That would be false.
Yes. Now it sounds true, and that's sort of intentional. We kind of do this to be tricky because you've probably heard that term. You've heard those numbers. Those things sound familiar. A foreclosing lender is required to pay 1% or 12 months of delinquent assessments. That 1% or 12 months is called safe harbor. So you've probably heard that before. A lot of foreclosing lenders are protected by safe harbor. They do fall into that category. And safe harbor under the statute requires that they pay 1% or 12 months. Now, 1% or 12 months might actually be the best you're going to do. Even though I know you're going to tell me, wait a minute, what do you mean we have to lose out on assessments, and why does the lender only have to pay 12 months or 1%? Well, 12 months or 1%, if you're the foreclosing lender and you're the first mortgage holder, like I said, that's really your best case scenario as the association. The association might be in a worse position. The association might be getting nothing if the governing documents that you have basically say that a lender doesn't have to pay once they take title, or pay the old amounts, I should say, and they only have to pay going forward. So if Bank of America forecloses on, your delinquent, Bob Jones in the community, Bob Jones hasn't paid in 3 years, Bob Jones owes the association, $50,000 at this point, and the board is chomping at the bit. We need this property to get sold because no one's paying and no one's paid us in 3 years. Well, that $50,000 debt, once Bank of America takes title and they foreclose their first mortgage, well, now the association, often the board will say, okay, so doesn't the bank have to pay us that $50,000? No, they do not. That amount goes away. That essentially, what they may have to pay you is 1% or 12 months of maintenance, the lesser of, by the way, or they may pay you nothing depending on what your governing documents provide. So you want to look at what your governing documents say, because this turns into a whole argument of which controls the statute or your governing documents. The statute might be better. The statute might give you more of a recovery. So in this case, if that's something where you have old language where the documents say Bank of America would pay nothing of the old amount, so $50,000 is, written off, Bank of America only pays going forward. If your governing documents say that, that's the easiest amendment I can suggest to you to get passed, because all of your owners are going to say, what are we doing? We're just, again, leaving money on the table. We want to recover as much as we possibly can, especially if we do have some of those, delinquent owners who end up getting foreclosed on. So that's a big one. And you want to really look at your documents. Again, you're going to get your owners probably to support that, no problem. Another part of that consideration is, so it's not just Bank of America. If Bank of America forecloses, and in that foreclosure action, somebody else ends up taking title at that sale. So it's a Bank of America foreclosure on Mr. Jones, but 1, 2, 3 investors ends up buying the property. Okay. Then the question becomes, well, what does 1, 2, 3 investors owe us? They're a new owner. They're going to pay us going forward. Great. But what happened to that $50,000? Well, if 1, 2, 3 investors, is considered a third party purchaser. If they, depending on the language in your governing documents, they may owe everything, but they may owe nothing. It may be the same issue with, again, what the language is in your governing documents. They may say we fall into the shoes of the lender, so we owe you nothing. And if your governing documents are written that way, that could be the case. Or since the statute does not protect them in that same way, they're not the first mortgage holder. They were not the lender. They just bought at the lender's sale. You may be able to recover all of those old amounts from a third party purchaser. But again, you have to change your documents to make sure they say that. All right. Another one, landscaped grass lawns must cover the bulk of the front yards in our HOA. True or false? Now, most owners are going to say, well, but we do have ARC guidelines. We require that everything be grass because it's prettier. We don't want owners to have, whatever else in their yards. And I completely understand the mentality behind it, but technically it's false because the statute says we have to allow, the association has to allow owners to basically install Florida-friendly landscaping. That's the term. And that is actually a defined term, and it does require some analysis, basically, if you have an owner that applies to put something in. Now, it's not going to be turf. That's not considered Florida-friendly landscaping. But certain things like certain rock beds and cacti and succulents, that kind of thing. The idea is that it's basically saving water. So the statute comes into play because it's going to control over what's in your governing documents here. And we're going to have to let certain things be in the front yard no matter what. Now, if you have old language that doesn't kind of allude to that or doesn't mention that, you may sort of, again, be kind of shooting yourself in the foot because you don't want it to look like you wouldn't allow that because we're going to comply with the statute if we have to comply with the statute. So that's something where you might want to do a quick amendment and address the fact that you would follow the statute and you'd have to allow the Florida-friendly landscaping. Again, it has to do with water and energy and all that fun stuff. All right. So another interesting one, the board has sole decision-making power when it comes to filing lawsuits. So again, it sort of sounds like that is correct. And for the most part, that is correct. But it's still false, technically. So in the world of HOAs, condos are different, but in the world of HOAs, there's a section of the statute that says that the declaration cannot contain a provision prohibiting the association from suing the developer. So the developer can't try and be sneaky and put something in the declaration that they've written that says you're not going to be able to sue us once we turn over. But there is something that the statute kind of, it's almost a runaround, but here we are. The statute says that the association cannot commence litigation against any party where the amount in controversy is over $100,000 unless the members vote to authorize that action. So the board would need the vote of the owners, and it's a majority of the owners present at a meeting at which quorum is obtained if the amount in controversy is over $100,000. So while those don't on their face sound like they go together, those points do go together because typically if you're commencing litigation and the amount in controversy is over $100,000, it's probably because the board wants to sue the developer. So developer cannot put a provision in the deck that says you can't sue us, but at the same time, to sue the developer, most likely you need membership approval because if it's an amount in controversy over $100,000, the board can't make that decision by itself. The board needs the vote of the owners. All right. Now, this one is a complicated one. We're gonna try and keep it short and sweet. But All new owners go through the screening process in our community. True or
False.
false? False. So here's the thing with screening. First of all, we have a whole class on just screening alone where I get to talk about screening and sale approval and lease approval and all that fun stuff for an hour just on that topic. So like I said, I'll try and hit the high points here and keep us on track time-wise. Big thing with screening is you need to, and this is the takeaway from this whole class, but you need to check your governing documents. What authority does the board actually have? What authority do you think it has? And make sure, what authority do you want it to have? And make sure the association's authority to review sales, leases, syncs up with what your practice is. Are you doing applications? Are you requiring screening? Do you require background checks? All of that stuff. And for what kinds of transfers? So important thing here is, do your governing documents require a membership or require any potential new member or new owner to apply if it's a sale? Okay, that's probably pretty clear. What about leasing? So sales and leasing, we can usually decipher. That's usually pretty clear in the language in your governing documents. But then there's always a question, well, what is a sale? And I know that sounds silly to say, but it's true. You'll have people say, well, I didn't sell the property, or it's not a purchaser. It's a quitclaim deed. I'm executing a quitclaim deed, or I'm putting the property into an LLC or a trust. Well, does the association have the authority to review those transfers? That language needs to be very clear in your governing documents. Could you deny a potential transfer based on that? What if it's a gift? What if it's a devise? What if it's an inheritance? All of those types of transfers, if the board wants to be able to review those and potentially deny them, you need to have that authority very clearly written in your governing documents. To review any type of sale and really be able to deny, you're going to need the right of first refusal. That's a big one. And you need to make sure you have updated language, essentially, or the right language. If it just says that the board has the ability to deny, but it doesn't spell out the full right of first refusal provision, then potentially that's subject to challenge. And the right of first refusal is a little confusing and a little tricky, but basically what it says is the association, because we really value the ability of owners to be able to sell their property. If the association has the authority to essentially stop that and deny a sale, it has to then, in connection with that authority, it has to have the right of first refusal. What the right of first refusal is if an owner wants to sell the property and the association denies it, there's language where it basically says the association will provide a substitute purchaser to step into the shoes of that purchaser. And either that could be the association or that could be another individual or entity that the association provides, so that the seller is not going to be harmed in any way because they're still getting their sale. They still get to sell the property, and they no harm, no foul, same amount, all of that kind of thing. But the kind of workaround, if the association, you only really need to exercise the right of first refusal if you don't have good cause to deny the sale. So you want to make sure that your documents actually spell out what good cause is to deny the sale. Because if you can point to your governing documents to say, well, we had authority to deny this sale and we had good cause to do it because here's our criteria. We require that the new purchaser have XYZ, and we can put in factors about criminal history. You can put in factors about the finances. And all of that we would suggest obviously doing with your attorney, having your attorney draft this amendment for you. All those are all things that the board can then look at and then point to say, well, we are on good grounds. We're solid. We can deny your sale without having to provide you with a substitute purchaser. Okay. And then you have to look in terms of, we kind of talk about all of these things. Does that also include when we talk about screening and we talk about lease approval rights? Are you reviewing every occupant that comes into the community that wants to live there? Do you screen your guests if your guests stay longer than a certain amount of time? Do you want the authority to review those individuals? Do you have people in your community who say, I'm not renting, that's just my cousin, he's coming to visit for you know, that individual will be there for season and I won't be in the unit, but he's not renting. Don't worry. It's just my, it's just my friend. It's just my buddy. Well, do you want to be able to screen that buddy? Maybe you want to have language in your documents that say, well, we're going to screen anybody, regardless of whether or not you claim they're a tenant, regardless of whether or not we can prove they're paying any rent. You could put language in your governing documents that lets you screen any guest, occupant, whatever we want to call them, a guest who's there maybe over 2 weeks. Maybe that's a little short and you don't want to do that in your community. Maybe you want to review any guest who's there over 30 days because now we're going to consider them a tenant. Maybe we have different thresholds for a guest who's there. If the owner's there, maybe that's okay and we don't mind. But if the owner's not there and the guest is there, maybe we do want to screen that person. Maybe that's, if they're there 2 weeks, we want to be able to screen them, or 20 days, we want to be able to screen them if the owner's also not there. These are other ways you can kind of prevent and keep an eye on leasing too, because obviously we have a lot of, in South Florida especially, we have a lot of people who want to circumvent the lease restrictions and they'll say, I'm not leasing, wink, wink. It's my buddy just coming to visit. Well, maybe we want to make sure that buddy doesn't have a criminal record, something like that. And when I say that also, the criminal screening, all of that, that's something that you have to be really careful about. We want to make sure that you don't put in criteria that could accidentally be discriminatory. If you have certain restrictions, if you do say, well, any criminal history means we deny the sale, or we deny the purchaser, we deny the tenant, whatever else, that's potentially an issue. That could be a discrimination. You could be on the wrong side of a discrimination claim if that's your policy. HUD wants us to look at the actual crime, how recent it was, the seriousness of it. Was it just a charge? Were they actually convicted? Was it a misdemeanor? Was it a felony? Does it have to do with, drugs? Is there really a safety concern for our community? Or was it, that they wrote a bad check 30 years ago? Those are different things. And all of that you can really kind of narrow down, draft criteria, work with your attorney to put criteria in the governing documents so you can really, narrow down the screening process. And obviously sometimes there's exceptions even for family members. That's why I make the joke about, the cousin coming to visit or whoever, or my brother's coming to stay with me. In a lot of the 55 and over communities now, we're seeing, sort of the adult son who moves back in with mom because he's fallen on hard times. Well, can we screen him? What does that mean? That's a question we get a lot. If you're in a 55 and over community, you need to be doing surveys. So you should know who's in each unit. But now, does that mean you're running background checks on this person too? Not necessarily. Only if that authority is in your governing documents. If it is one of those situations where you have an owner who, again, 80-year-old mom and 50-year-old, again, sort of bum son moves in, and you have the owners who all of a sudden do a little Googling and they find out, hey, that guy actually has been arrested a bunch of times. He just got out of prison, or, whatever else they can find in this lovely hypothetical. So you'll have your owners say to the board, you got to get rid of him. Well, can the board get rid of him? Can the board screen him? Do we have any authority to do that? They're only going to be able to do that assuming he's moved in and hasn't been a problem. But they can only do that if that authority is in the governing documents. Can you screen that individual? Now it's an adult son, it's a family member. Do you have that authority as well? All of these considerations, all of these scenarios come up in the world of who can we screen? What authority do we have? Can we run background checks? And those are very, very important concerns, obviously, on a daily basis for a lot of our clients. And the key is always going to be, what do your governing documents say? Make sure that you have the authority that you want to have, and that you think you have, and that you are properly enforcing it, but make sure your documents actually outline those restrictions for you. So that's a big one. And that ends up you end up potentially with a potential discrimination issue if you don't have that done just right. All right. This is another sort of legal hot topic, if you will. For most regular owners, this is not something you would think about, but if you're on the board, or if you've heard some of these classes, or if if you're an attorney, this is something that might, keep you up at night, essentially. Once the law changes, the change is automatically applicable to your community. True or false? Well, false. So we talked about the hierarchy of your governing documents in the beginning and how a little dab will do you. Declaration, articles, bylaws. Another factor when we're talking about what controls and how you guys sort of conduct business and operate as an association, the statute. Now, a couple different statutes to consider. 718 is the Condominium Act. You hear people call it that. Chapter 719 controls for co-ops. And then Chapter 720 is the controlling statute for HOAs. So they are different. You have different requirements. They do not all sync up. They do not mirror each other exactly. Some provisions they do, some they don't. So you do have to make sure you know which kind of association you are and which statute you're following. Also, there's some other statutes that might come into play. Like we talked about, some energy ones, and the next one references statute 163. That has to do with clotheslines and energy, but there are some other statutes that will come into play sometimes. Chapter 617 is the not-for-profit statute. You guys technically do fall under that as well because you are a not-for-profit. But generally, your controlling statute is going to be, again, 718 if you're condo, 720 if you're an HOA. And then sometimes the 617 is kind of your fallback to fill in some gaps. But big question is, what if there's a conflict between our documents and the statute? Which one do we follow? And that gets very complicated. It's a complicated analysis. If your declaration was recorded, drafted in the year 2000. So since the year 2000, the statute has been changed a number of times. Are we listening to what the statute said in the year 2000? Or are we listening to what the statute says now in 2026? And then, like I said, which one is going to control? Is it what's in our documents or the statute? And again, which version of the statute? There's a whole legal argument here. There's a whole legal analysis that needs to happen. But essentially, the takeaway is, and I hate saying it, but the answer is always, it depends. If the statute changes and the changes are considered procedural, that will apply to you in regardless of what your governing documents say. So you follow that version of the statute, the procedural changes will apply. If there's a substantive right that you have in your governing documents, because again, your governing documents are a contract, your declaration is a contract, and there's language that essentially the statute can't impair a contract. And again, complicated legal analysis, but that's the gist. Statutes can't impair a contract and a contractual right. So if you have a substantive right in your governing documents, potentially that's going to control, probably that's going to control, and the statutory change doesn't apply to you. But again, there's a bigger analysis, and if you do have a question about this, talk to your attorneys. Where it comes up most recently has a lot to do with the changes in 720 from a couple of years ago, where they put in a part of the statute that says now that the association can enforce a covenant or restriction that prohibits someone from keeping their work truck, basically, where it's allowed to be. So owners would be able to park their trucks in their driveways. Now, this is where we get into that analysis. Well, but our HOA, our governing documents have always said that a work truck, a commercial vehicle, a truck with letters, whatever else, cannot be parked in a driveway overnight, must be parked in the garage, or can't be parked on the street, can't be parked in our community. That's always been what our association has had. So why does the statute get to come in and say, never mind, you can't enforce that? That's the conversation here. And then you have to look at, do your governing documents have Kaufman language? Kaufman language means you follow the statute as amended from time to time. That would mean that if your declaration was recorded in 2000, you're following the statute as it changes, and you are basically subject to the 2026 version now. If you don't have that language, that's where we get back to the analysis. Well, are we looking at the year 2000? Or are we looking at 2026? So all of this factors in there. And that issue with the trucks has come up most recently. That's the big one. That's something to discuss. If that's something that impacts your community, talk to your counsel about it. There were lots of articles originally saying, oh, it's a victory for the homeowners because now owners can park their trucks in their driveways. And that was in the news. And then a lot of attorneys had to say, whoa, hold on a second. Maybe not. And then and we're back to this lovely complicated conversation. All right. Residents are prohibited from having clotheslines in your HOA. That's something that, again, you might have that language in your governing documents, and realistically, you got to take it out because now the statute, that's one where the statute is going to control, and you guys are sort of out of luck. Section 16304 prohibits HOAs from enforcing document prohibitions basically against energy devices. So clotheslines, solar panels, that kind of thing. Now, that doesn't mean it's a free-for-all. You can have some provisions in place that allow, the association to have rules about where these things can be kept. You don't have to have clotheslines, in the front yard. You can maybe say they have to be in the back or the side or something like that. Solar panels are a little tricky because they have to be able to work. They have to be able to function. So you might want to have a provision that says you can't put solar panels on the street facing side of the roof, but that policy might not be enforceable. That rule might not be enforceable if that is the only place that the solar panel could be, located and still work. They have to be in a certain orientation, basically southward, so they can get sun. So we get that question a lot. Can we at least tell people they can't put solar panels on the front of their house? Well, maybe, maybe not. All right. Our community can enforce rules prohibiting minors from using any of the rec facilities without an adult present. Also false. So now again, if you're a 55 and over community, these rules change for you a little bit, okay? Because there's discriminatory claims and discrimination issues when we deal with families with children. That is a protected class. But obviously, if you're 55 and over, I kind of joke that you're legally allowed to discriminate now, because that is, you discriminate based on age, essentially, because we're requiring that somebody occupy the unit or occupy the property who is at least 55 years of age. So now you are sort of allowed to factor in age and all that stuff. But we still have to be careful discriminating against families with children. That also includes pregnant women. So any, certain provisions you might have in your declaration or in your rules, you may not even realize sort of end up having a discriminatory effect, even though you didn't mean for them to. So we don't want you to have any rules that really, that use the word children. And that's a bad idea, generally. General takeaway, don't have any rules that are targeted to children. If you're worried about, the behavior and the actual effect of what is happening, make your rules so that it doesn't target children. Just phrase it in a way where you're actually addressing the behavior. No, we don't want diapers in the pool. I get it. But that also means you don't want adults with diapers in the pool. So you can have a rule that no individual wearing a diaper can come into the pool. You don't have to say no children with diapers in the pool. Things like that. That's something else to consider. Now, again, so families with children fall under a protected category. You need to make sure that any language in your declaration, any language in your rules aren't going to subject you to a discrimination claim.
Emily, before the next one,
Yeah.
just really quick,
Yeah,
folks, we're almost done. We have only a few more slides left. So I just want to remind everybody, if you haven't already done so, press the chat button so it appears on your screen, because now the evaluation at the end is required. So we're going to place the link for the evaluation into the chat. So if you haven't already done so, press the chat button so you see it, so it shows up, and look for that link in a few minutes. And also, those of you typing questions into the Q&A, let me remind you, course topic questions should only be placed into the Q&A module, not the chat module. Okay, we're ignoring the chat module when it comes to class-related questions. Back to you, Emily. Thank you.
Thank you. All right, so a couple more things. Board has to obtain a vote of the owners before making any material alterations. False, but again, it's really just to tell you to look at your documents first. Condo statute addresses material alterations and basically says if your governing documents control and they say something, you follow your governing documents. If they don't, you have to get a vote of your owners. And again, your threshold in your governing documents might be lower than the threshold that you would need otherwise under the statute. The HOA statute is a little different. There really is nothing in the statute, so you have to look at the governing documents. Material alterations isn't usually a term we use in HOA world, but often the governing documents will say that the board can spend up to 5% of the budget or $10,000, and anything beyond that on an improvement or a capital improvement or something along those lines would require a membership vote. So you need to see what that language is in your governing documents before you do one of these projects if you're thinking about, doing a big spend on a big improvement. And again, if you do have any of those projects coming up, think about amending your documents first so that maybe you don't have to worry about getting the vote. Another big one when we talk about saving you guys money or, not leaving money on the table, what about your delinquent assessments? The governing documents, the bottom line is your governing documents will allow you, probably, allow you to recover something in addition to just the delinquent amount. But the statutes, all of them, 718, 719, 720, say that if you want to charge a late fee and if you want to charge interest, which both of those things you could get and you could charge on a delinquent account, but that language would have to be in your governing documents. So you have to have the authority in your governing documents to charge interest and to charge late fees on delinquent assessments. If you don't have that authority, or if you have old language that maybe says, you can charge interest at 10%, we want to get that updated for you. We want to bring you up to, 18% and a $25 late fee, or, whatever the statute provides. If the statute gets increased at some point in time, you would want language in there that says, we can charge the highest amount allowable by law. That's an easy amendment. That's an easy, sell to your owners probably. Another one to consider, what about a pipe? What about your maintenance obligations? Okay, we have a pipe in the wall that serves only one unit. Is it the maintenance responsibility of that unit owner? Well, maybe, sometimes. Again, statute's not going to address maintenance requirements for 720 or 718. So if you have a maintenance concern and you're not sure who takes care of what, that's spelled out in your governing documents. And if your governing documents are not well written, or they're confusing, or they don't really address every little maintenance item, maybe that's something you want to amend to make it clearer, to make it, just easy for everybody to understand. Or potentially you want to change the maintenance requirements. Well, we don't want our owners fixing pipes necessarily because we'd rather have our guys do it. But if it's a pipe that only serves their unit, maybe we do think they should be the ones to pay. So you could draft your amendment in such a way where the association does the repair, but that unit owner is responsible to pay for it. Maybe that's sort of the happy compromise. All right, so here's a little summary page. I'm already kind of over time, but this is kind of some key points. Take a look. Bottom line, we want you to be able to maximize your recovery. That's a big reason for these amendments. We don't want you to be exposed to liability and discrimination claims, because that's going to cost you a lot of money to deal with. So, anytime anyone says, well, why do we need to spend the money to amend our documents, or documents are fine, they've been in place for 30 years, 40 years, 50 years. These are the reasons that you can kind of try and get people to realize it is important and you should think about it. And I know we include this extra sort of bonus slide here on electronic voting. And the only reason that's in here is because, like I said at the start, big question we always get is, well, we can't get the involvement. So how do we get people to come out and vote and do these amendments? The only way to get the amendments, passed is for a membership vote. So if you can make voting a little bit easier for everybody, that might help too. Look into electronic voting. If your owners can vote, through an app on their phone, you might be able to get them involved if it's a little bit easier. So that's something to just consider. So we kind of put that in there for you. All right, so let me look at our questions real quick.
Yeah, you're not over. We advertised an hour and 15, so we're in good shape, because I knew I'd be doing a lot of talking at the beginning with the new procedures. So folks, while Emily's looking through the questions now, she's going to go through some of them and address any that are on topic, that are not novels and are not too association specific, because we don't have your documents in front of us.
Right.
I want to quickly mention that we did place the link for the evaluation in the chat a couple of times already. So if you have not yet done so, press the chat button so the chat area appears, not to be confused with the Q&A button. The chat button is a separate area. I'll place it in there again in about a moment, because you won't see it if you didn't have the chat button already pressed. While I'm doing that, I want to reiterate to everybody, you'll be able to save the slides after submitting your evaluation. There'll be a screen, a confirmation screen. You can click the link, save the slides, and that's it for now. When Emily's done with some of the questions, I will come back. For any of you struggling with the technical aspect of the evaluation, I will share my screen and go over it much more slowly. Emily?
All right. I see some good ones in here. So someone said, we want to change our bylaws for the number of board members needed. Can that be done only by an owner vote to change this one issue? So that's something where your governing documents might actually say that the owners get to decide the number of board members. So you may be able to do that without an amendment at all. You might be able to do that with just an owner vote, or potentially it may say just the board gets to decide, a number of board members, odd number between 3 and 7, as determined by the board from time to time. So that if it's written in that way, as determined by the board, then the board gets to decide, oh, we want to go up to 7 or whatever it is. If it doesn't say as determined by the board, it might say as determined by the membership, then you would need your members to vote. If it is just a fixed number, if your bylaws say the board consists of, 5 directors and that's it, then perhaps you do need an amendment to change that. So all of that, and that's a good question, because essentially there's 10 different ways that provision could be written, and I could answer your question, because it all depends on what your governing documents say now. So, and then whether an amendment's needed or just a vote is needed. And then someone also said, can the threshold percentage be different for different issues? So membership vote required to pass a material alteration could be 1%, versus the percentage required for an amendment, the percentage required for termination. And yes, essentially those are all provisions that are probably in different places in your governing documents. The material alteration vote might be a 75% vote. You could reduce that down. That if your amendment provision was already reduced, that's not the same thing. You could change all of those, and they could all be different numbers. So that's something you need to look at, and that's something that, again, it's not just 1% across the board for your governing documents. All right. Somebody said, our condo docs say we can't own more than 1 unit. If you're gifted a condo in the unit, but you're planning on transferring, what would be the time limit to do so? Again, that's something that sounds like that's really a document-specific provision. That is a restriction we've seen, that you're limited to only own, 1 unit in a building or 2 units in a building or in an association. That's not uncommon, because again, we want to kind of keep investors from buying all the units up. But ultimately, you'd have to talk to the board about how they want to handle that. I assume they'd give you time to turn around and sell one of the units. Let's see. Someone said, can we take Kaufman language out of our governing documents if we have it? That's a complicated one too. Then there's sort of an argument that you had it up to that point and then it changes the analysis. So again, talk to your attorneys about that. If the documents don't have Kaufman language, so Kaufman language, just to reiterate, Kaufman language is we're subject to Chapter 718 or Chapter 720 as amended from time to time. Those are the magic words that you hear everybody say. Kaufman language basically means we follow the statute as amended from time to time. You can put that into your governing documents if it doesn't have it already, but you don't have to put it in. There's also language that you could put in that you can say, well, we are still subject to, Chapter 720 as it was in the year 2000, but for where we indicate otherwise or something, where you could then reference updates to the statute in just certain places in your governing documents. But it does get kind of tricky, and that's something you want to talk to your attorneys about too. Let's see. So someone said, if the association does have the right of first refusal, please explain the process of providing an alternate buyer or the HOA purchasing if they have the original purchaser. So again, you'd have to follow the procedure in your governing documents, but essentially, if this is one where you don't have good cause to deny the sale, and the association is in a position where we can't deny without having to exercise the right of first refusal, then you notify the seller that, okay, well, we're not approving your sale, but we are going to exercise the right of first refusal, and we're providing you with a substitute purchaser. So let's modify the contract and let's get this, closing going. And then you obviously want your attorneys involved to help you get it done logistically. But ultimately, where we've seen that done, some clients have said they don't like that, a sale was proposed at a really low price, and they had no reason to deny the sale. The purchaser had good credit. The purchaser had a clean history. There was no issue there. There was no good cause to deny it. but they just didn't like that the purchase price was so low. So the association said, we're going to step in, we will buy the unit, the association will purchase the unit, and then we'll turn around and sell it because we think it can be sold at a higher price. And then that way we don't have this last sale in our books as this lower number. So that's where we've seen it happen more common than anything else. Can you set an age for pool access without an adult present? So that's one where, like I said, you have to be really careful how you do it. And these rules are supposed to be based on safety, right? So it really isn't supposed to be just based on, well, we don't want kids at the pool because kids make noise and they jump and they shout and they play and they do whatever. Well, newsflash, adults do that stuff too. Some adults are really annoying by the pool.
Just go to a board meeting. Sorry.
Yeah, right. So, so the issue is not, we don't want kids by the pool because we don't want noise and we don't want, fun and noise, rowdiness or whatever. That's not going to cut it. It's a safety concern. Your rule has to be related to safety. So I understand you don't want a 3-year-old at the pool by themselves. Totally makes sense. That's a liability. That would be horrendous. But you do start getting training for, I think the Red Cross starts doing lifeguard training at like 12.
Yeah, it's really young. I think we went over that last month. Yeah.
It's lower than you would think it is. So if someone can be trained as a lifeguard at 12, then it doesn't sound so reasonable to say, well, we're concerned about their safety. That's why they can't be by the pool by themselves. So all of those things need to be considered and taken into consideration, and talk to your counsel about adopting those types of rules.
Yeah. Emily, community association living is all about being reasonable.
Right. Which no one is nowadays. Someone said, what constitutes a material alteration? Good question. It is a very long, drawn out, complicated definition that basically says you are palpably, perceptively changing the appearance of a common element, building, or function, or something along those lines. And it's a hard definition to actually, really work in when people ask us, hey, is this a material alteration? Maybe, probably. The division is very conservative about their material alterations.
Right.
To them, it seems everything's a material alteration.
Everything. Yeah.
So you really, if there is a question, talk to your counsel. If we're talking, hey, we are, we're gonna paint the buildings, we would think that's not really a material alteration, but there's a case or a division case, arbitration case with the division where the division says, yes, changing paint color is a material alteration.
There are some tricky ones out there.
Yeah. So that's one that for sure would be a material alteration. If you're talking, well, we're just going to put new lines on the tennis court so that can be used for pickleball, is that a material alteration?
But not taking away the tennis function.
Right.
Serving both.
The tennis court now. It can be a complicated analysis. Talk to your counsel about it.
Right.
All right. Let's see. There are a couple things that are in here. Somebody who couldn't log on. I don't know, Jeff, just to let you know.
Say that again. I'm sorry. I was looking at the chat for
comment. Yeah, that they couldn't log in and they put their information.
Yeah, folks, after the event's over, we check the timestamps of everybody that came in and out. So we know, for example, Emily, we didn't get to the first slide today until about eight or 9 minutes after because of all the housekeeping. So if you got in late and you were, we do give some grace at the beginning. And if your technology fails, if you have internet, if the internet bumps you off, and on the timestamps, I could see that you made the effort to come back in within a couple of minutes. You'll be fine. It's those of you that come in at the beginning, leave for 45 minutes, come back at the end, submit an evaluation, and think you're going to get a credit. That's not how this works. So you should be fine if it was a quickie. Don't worry about it.
So someone said our community is updating our rules and regulations. They don't want to have the attorney look at them. They want to just approve them and have them updated. Shouldn't the attorney look at it? I'm going to tell you, of course, the attorney should look at it. But obviously your board is going to do what they want to do. The issue with rules and regulations, keep in mind, your rules are only going to be effective if, and there's a couple things. You have to have the authority to adopt the rules. And that sounds silly because you probably do have that authority, but sometimes your rule authority in the bylaws or in your declaration only says something like the board can adopt rules about the common areas. It doesn't necessarily address the units or doesn't address the lot use. So that's something you want to check. Your rules have to be reasonable. That's what we just said. Any rule needs to be reasonable to be enforceable. And that's something that is obviously a little subjective and hard to kind of gauge necessarily. But any rule to be enforceable has to be reasonable. And then the third thing is it can't conflict with what's in your governing documents already. So if you have something in your declaration that, it maybe isn't addressed, there's a restriction that is not included in there, and you adopt a rule that creates a new restriction, essentially, potentially that's an enforcement issue. So that may be something you'd want to run by counsel to make sure you're not doing that. Because if you're going to adopt a whole bunch of rules and then you start sending out violation notices and you get an owner who gets, a little savvy or gets an attorney and says, well, wait a minute, you guys can't enforce this. What's this rule? It's not properly, it's not proper. It wasn't adopted correctly or whatever it is. It wasn't done right. It really needs to be in your declaration. It can't just be a rule. Then you're sort of shooting yourselves in the foot and you're going to end up getting your attorney involved one way or the other. So, all right.
There's one thing here. Somebody mentioned here, for some reason, after filling out the survey and filling in all the necessary areas, when I hit submit, it just comes back to the form. I don't know what's happening. A couple of things could be happening. Make sure all the fields with an asterisk have something in it. Make sure your email addresses match. You have to confirm your email address so we can get the certificate to you. And lastly, a lot of folks sometimes they'll check the "I'm not a robot" box, hit submit before waiting for the check to appear in the "I'm not a robot." It sometimes can take a couple of seconds. And remember, just like buying tickets on Ticketmaster, when something goes on sale for the first time, many of you are doing this at exactly the same time, which can slow down the server a little bit. So try again if it doesn't work.
And then a follow-up to the rule issue, someone said, without a community vote. So your rules are basically going to be adopted. And again, I know I sound like a broken record, but in accordance with your governing documents. If your governing documents don't say that the owners have to approve rules, then the board gets to adopt the rules and it's a board vote and you don't have to present it to your owners. But again, like I said, if there's something that would conflict with your declaration and really needs to go in your declaration, then that would require an amendment. That would require a membership vote because it's an amendment to your declaration. But every now and again, some of the governing documents will actually say something like, board can adopt new rules subject to approval of the membership, as long as the majority of the membership also approves them or doesn't veto them. I've seen that language where basically you kind of have to hope your owners then don't vote on their own to veto your rules.
Yeah.
So it's really going to depend just on what's in your governing documents. So
Emily, do one more because we're 3 minutes before the advertised time. And folks, if we don't get to your question, it doesn't mean it was a bad one. It just means we had over 300 of you here today and lots of questions. And also, by the way, after you do the evaluation for this or any class, while we want you to hang out for the Q&A, you're not required to. So once we get to the final slide and once you submit an evaluation, your required attendance is over and you could either hang out or depart. That is entirely up to you. Emily?
well, I see a number of questions on Kaufman language. It's funny. I told you it is a hot topic, guys.
It
So
is.
if you guys are now sort of aware of it and you see this as an issue for your community, definitely talk to your counsel about how to address it. If it's something that you are thinking about doing some amendments, how you want to handle it. Someone said they have a president who's basically not collecting assessments for 3 months. How do we stop that? How do we make it, not the standard operating procedure? For your assessments, and again, the only part of that really is related to amending is confirming that you can collect interest at the highest rate, you can collect late fees. That's what I'm going to tell you in terms of keeping it to related to this topic in terms of what to do and to amend your governing documents. But in the world of assessments, the statutes are pretty clear. You really do want to be pretty aggressive collecting assessments because if the board has discretion, the board can enter into payment plans. You can try and work with people. Obviously, everyone's going to have a different, situation at home. They may be able to pay you some of it now and some of it next week. If you guys are quarterly, maybe that, you let them pay them monthly, whatever it is. You have the authority to exercise your discretion, but I'm going to tell you, you should really be aggressive. The statute changed a couple years ago where now there's an additional notice requirement. There's a notice of late assessment is what it's called, or a NOLA. You'll hear people say that. You can't put attorney's fees on a NOLA. So we typically don't draft them for our clients because we don't want you to pay when you can't recover that amount. Typically, your management team will send it. It's a 30-day notice. It says, here's the breakdown of everything that's owed, and you have 30 days to pay. Now, if you're still sending multiple late notices and sort of the friendlier, courteous, hey, reminder notices, and then you have to send that NOLA, you're probably months in. And now that NOLA is a 30-day notice, and then you send it to your attorneys. Once it goes to the attorneys for sort of official collections to start, now there's 2 more notices that go out before we could go to foreclosure. One that says we're going to record a claim of lien against your property if you don't pay us, and here's the amount owed, and we give them 45 days to pay because the statute requires 45 days. Then, if they don't pay, then we have to send a second notice that says, hey, we recorded that claim of lien against your property because you didn't pay us, and you have 45 days to pay again. And if you don't pay the amount this time, we're going to send it to foreclosure. And if they don't pay, now we're going to foreclosure. But in that time, just to get to that point, we've sent 2 45-day notices. You guys had to send a 30-day notice. And I don't know when that clock started, how delinquent they were to begin with. But we're talking, at least 120 days, and that's fast on the fast end. So assuming some admin time and getting everything kind of coordinated, you're months into this person being delinquent. Months, and possibly even, almost a year by the time you file the foreclosure, 9 months in. So be a little more aggressive, because ultimately you guys have an obligation to collect assessments. How else are you going to budget? How else are you going to do your projects?
Function.
You can't have everybody else, carrying these people for forever. So, all right. Someone asked about smoking. That's an interesting topic too, and becoming a no smoking building. So I assume you're probably a condominium. That's something where you can probably by rule adopt a policy that you can't smoke sort of in the catwalks or in the hallways or by the pool. But to prevent owners from smoking in their units individually, that I would suggest you do as an actual amendment to the declaration. So
That's a tricky one as well, because then you have to about grandfathering people in and stuff like that who moved in when there were no stipulations.
Yes. That's the other thing to keep in mind. When you draft these amendments, you have a little, creative leeway too. So talk to your attorneys about how you want to do it. You could draft amendments in a way where this is going to apply going forward to everybody who takes title after, and everyone else kind of gets grandfathered in.
Yeah.
Maybe the example that one person had about, owning 2 units. That's how we would typically draft that. If we wanted to put that into effect now,
Right.
we would say, well, if you already own the units, that's fine. You can still own your units, but going forward, any new owners can't own, 2 or more units. But you can also draft them in a way where the amendments apply to everybody. You don't have to grandfather people in, but obviously all of that factors in strategically, because who's going to vote in favor if you're going to adopt an amendment that all of a sudden puts them in violation?
And you made an excellent statement there. I mean, all of your statements are excellent, but one in particular about talking with other people to see what they did. You alluded to that. Emily's going to be, for those of you in the South Florida area, on. Are you going to be at the bowling alley on March 31st for the ACE event?
Yes.
Because at the ACE event, Emily will be there, and you're going to have lots of other board members and managers for the free education. You get some free lunch out of it. Then you can bowl a game. It's going to be complimentary.
Yeah.
Emily will be there, but that's a great opportunity to see some of your peers, fellow board members, fellow managers. Say, hey, I have this situation. How the hell did you handle it? Give me some ideas. So it's great to get out there with some of your peers and find out how challenges were faced in similar communities.
And I take no offense, because we have board members that say, hey, we talked to the building next to us and here's what they did. Could you do it that way? Sure, no problem. If it's working for them, and you wanted to save some attorney time and, pick their brain before you came to me, fine. I have no problem with it. So, all right, Jeff, are we all done?
We are. I know you have to get to some appointments this afternoon before you call it for the weekend. So, Emily, excellent job as always. You can reach Emily at egannon@kbrlegal.com. Correct? Did I get that right?
Yes. Yes.
All
no
right.
relation to the tax collector. I get benefits in Palm Beach County. Sorry.
It's all your fault. It's all your fault.
I know. So, all right, guys, thank you so much.